members to take their seats. We're going to do a quick roll call to see what committee members are on WebEx. If you would, sir.
Debbie Beavers, Jordan Mahalahan, Matt Sterling, Michelle Segan, Roman Bueller, and Samantha Potter.
Samantha Potter. Right. Samantha, are you in the Capitol?
I will be in about 30 minutes.
Okay, thank you. If we have a vote, if you're in the Capitol, you may vote. If you are not in the Capitol, please don't vote. Thank you. We will be working some bills. But first up, I need a motion to approve the minutes of 1/15/21. Representative Heiberger. Got a second. Got a motion from the Vice Chair, second by the ranking member. Any discussion? All in favor say aye. They are approved. First up is House Concurrent Resolution 5013. Matt, if you would.
Thank you, Mr. Chairman. Good morning, committee. House Concurrent Resolution 5013 would urge the United States Congress to propose the Keep 9 Amendment to the United States Constitution. That resolution would require that the Supreme Court of the United States would be composed of 9 justices. And then if this resolution was adopted, it would be sent out to members of the Kansas congressional delegation, the Speaker of U.S. House, the Majority Leader of the U.S. Senate, and then the leader of each legislative chamber for the other 49 states. Happy to try to answer questions.
Thank you. Questions for the reviser? Seeing none. First up will be Representative Stephen Johnson. While he's coming up, I want to tell the committee, 9 years ago, he was my first chairman, and I carried my first bill, and it was a Capers bill. I recall as if it was yesterday. It was a very complicated bill. We made probably 100 changes in the Capers statutes, and he was standing there with me. I was a nervous wreck. But many of the things that I do in this committee, I attribute to Representative Johnson. As in many things in life, you always remember your first. So, Representative Johnson, Stephen, welcome to the committee, please.
Thank you, Mr. Chair, and thank you for the kind comments. I'm glad to be here and get to rise in support of the Keep 9 Amendment. I am well outside of my wheelhouse, and I know many of you know the details on what's happened in the court and the issues far greater than I. The only number in this is 9, so perhaps I should say that and then stand for questions, but I'll go a little deeper. The Keep 9 Amendment is one that has come up. There's another proponent to whom you could direct questions, go deeper. But the goal is to raise the awareness and the conversation around that issue again, and there is an effort to bring that all the way to the possibility of an amendment to the U.S. Constitution. But the purpose at the start of my testimony, my eyesight isn't too great with contacts on reading, but we want to keep the partisan influence from swinging the court back and forth. And that was an issue prior to 1869, and there were a number of changes that were made, some of them retaliatory, to change the balance of the court. There are some efforts that have been made since that time which have not been successful, but the amendment itself is in bold towards the bottom of my first page of testimony. And it reads very simply, the Supreme Court of the United States shall be composed of 9 justices. So it is the one effort at court packing or court changes that has bipartisan support. It specifically and uniquely deals with the fact that you neither increase nor decrease the number of members. The bipartisan support has been fairly long-standing. More recently, one of the to talk about it was Justice Ginsburg. If you Google Ginsburg, and 9 is a good number. You can find directly what she has to say on that. Ginsburg, her comments were 9 is a good number. Again, some of you probably already know that. Prior to her, Reagan's Attorney General, Ed Meese, was a proponent of keeping that number consistently on the court. Again, to just keep it consistent and from the political influence. It's become more of an interest recently, as during the presidential campaign there were comments around that issue and the possibility, and in the challenges and throes of campaigns that question was posed, and candidates were likely to say that I'll at least look at that. I don't know how firmly they were on that. I didn't follow that to the same degree as some of you or others would have, but it raised that awareness and is one that there was a bipartisan coalition that brought it last year, and there's another coalition working on it this year in Congress. In addition, several states have been looking at it, and as I mentioned, the goal that I have with this is just for us to have that conversation, to make us aware of it in Kansas, and if we would join that effort that is nationwide to say, we also think that 9 is a good number, and we would like to continue with that and continue with, most importantly, the consistency of the court. Those are the main comments that I have. I'm happy to stand for questions, and I'm happy to introduce another person online that can go in detail on what's happening with the effort and the history of the court.
I'm going to allow a few questions now because I know you need to go to Appropriations Committee. Committee, do you have questions of the, yes, Representative Heiberger.
Thank you, Mr. Chair, and thank you for being here, Representative Johnson. You mentioned that this resolution is an attempt to keep partisan influences from affecting the court. Is that accurate?
That is accurate.
Are you aware of the recent history of Supreme Court nominations in this country starting in about 2016?
So that is fair, and to keep influences, I won't pretend is possible, but swinging the number of justices would allow for perhaps wider swinging influences than typically happens with the consistency over time.
I'll save my further comments for when we work.
Thank you. If you would like, I have Roman Bueller on WebEx. You want to tell us who Roman Bueller is?
Sure, I would be glad to do that. I met Roman in Nashville when I was going early to a conference to speak on pensions, and he was working on the Regulation Freedom Amendment, which was another issue that I was really interested in at the time, and that ebbs and flows also, but at that point we had the waters of the U.S. and a few other things, and that was a resolution that we did pass House and Senate several years ago. And the issue that has bubbled to the surface for their team now, and he has worked with the Madison Coalition, and he can tell you more about that, but the Madison process of getting amendments on the U.S. Constitution is one then that that entity works to follow. And he may have several other hats, but I have appreciated his guidance just in looking at some bipartisan efforts of states to look at how do we move as consistently towards different policy initiatives as we might be able. And he had been available by phone or WebEx to share with us as well.
Thank you. And I apologize, I said Roman, but it's pronounced Roman. Mr. Bueller, are you on WebEx?
I am.
Sir, go forward with your testimony.
Thank you, Mr. Chairman. Thank you for the opportunity to speak to the committee today. The Keep 9 amendment, which I'm here to discuss, would be the shortest amendment to the U.S. Constitution. It simply states the Supreme Court of the United States should be composed of 9 justices. It would set the current number of 9 justices in the Constitution and prohibit a future Congress and president from altering the size of the court. And I think it's relevant for the committee to think about what would have happened had in the last 4 years one party been in complete control of the government and had decided to pack the Supreme Court in anticipation of election challenges that might be filed in the 2020 election. If we had had a packed court, a court packed by either party in the 2020 election, the divisiveness and the polarization that resulted could have been far worse. And for 150 years, we've depended in America on the respect that an independent court provides when it has to make difficult decisions. We rely on the popularly elected branches of government for most of our decisions. But when those decisions impinge on individual rights or minority rights, or the rights of people who are sometimes unpopular in the political system, we rely on a Supreme Court that's independent from the political pressures of the day to protect our rights, to protect our privacy, to protect the rights, particularly. And one of the instances of court packing took place more than 100 years ago. Most people don't know about it. But the President of the United States, who believed that his authority was virtually unlimited, decided that it was time to send the Cherokees across the country and to dispossess them of their land. And the Supreme Court said, no, you can't do that. The law doesn't allow it. There's a treaty. And this power-hungry, power-conscious President of the United States says, well, how many regiments essentially does this Supreme Court have? And he ignored the decision, and the rights of a vulnerable minority were trampled. And several years later, the size of the Supreme Court was expanded so that some of the judges that hadn't sided with the past president their votes were diluted by new members. So that's an example of what can happen when Congress chooses and the president decide they want to undermine the independence of the court. In fact, if you look at the history of court packing in the first 75 years of the Republic, there were 6 times, by my count, when the Congress and the president either expanded or shrunk the size of the Supreme Court. After 1869, tradition grew up that the court should be independent. Most of you are probably aware that in 1937, President Franklin Roosevelt sought to expand the size of the court. He was overwhelmingly defeated by a bipartisan coalition, which decided that president should have many powers, but the power to bend the Supreme Court to his or her will was not one of them. And so since 1937, most people thought that the issue had been settled, that people respected the independence of the court. But now, if you know, there are strong pressures to add justices to the court. And here's the problem, and it was actually most eloquently stated by President Biden when he was a candidate. He said, if one side packs the court, the other side's going to pack the court, and the court loses all respect. And he said that in 2019, and it was a long-standing position. And he's now about to appoint a commission that will look at this issue. And we think it's really important for people in both parties to speak out now about the fact that court packing should not be on the table. It should not be an option. And that we ought to put into the Constitution this tradition of 150 years that the court remains independent from political pressure. And in fact, the Keep 9 Amendment has bipartisan support. It was originally proposed by a bipartisan coalition of former state attorneys general. There were actually 15. A majority of them were Democrats. The chairman is a Democrat, a former state attorney general from Virginia. And the amendment was first introduced in Congress in late 2020 by a Democrat, Colin Peterson of Minnesota. So we believe that the only way to protect the independence of the court is with a bipartisan effort. Now, polling shows that at the voter level, an overwhelming majority of voters would support the Keep 9 Amendment. The numbers we saw in a poll were 62% in favor, 18 against. When you ask Democrats, the number was 49 for and around 27 against. So at the voter level, this has overwhelming bipartisan support. And so we believe that members of state legislators around the country can play a significant role in reducing the partisan polarization that seems to have overtaken our friends in Washington by urging members of Congress to follow the will of the voters and to preserve the independence of the court, and to take the threat of what could be one of the most polarizing, divisive battles in recent American history. I can't say the most after the horrible events we've seen in the last month or so, but to take that issue off the table and preserve the independence of the court. You know, people talk about the political advantages that one party or another party would get by packing the court with their partisans. And let's be honest, those advantages are significant. You can get a lot done if you have a majority of the court. But in 100 years, we're gonna wish, if we don't keep an independent court, we're gonna wish we had one, because an independent court is one of the things that holds the country together. When difficult decisions have to be made, the decisions that sometimes offend people on one side or the other of the political spectrum, it is an independent court that brings people together. And I'm sure we can all think of decisions that we didn't agree with on the Supreme Court, but that we supported because they came from a court that had the respect to make rule of law the dominant principle. And if we lose an independent court, if under partisan pressures, one party or the other, and it could happen in either party, if one party or the other packed the court, we would lose one of the things that makes America so special. So I urge members of the committee to consider supporting the amendment, and thank you so much for the time.
Thank you. Will you stand for questions?
I certainly will.
Thank you. Questions for, yes. Go ahead, Representative Lewis, please.
Thank you, Mr. Chairman. Mr. Bueller, do you feel that the Supreme Court should be lifetime appointments?
You know, that is a very, very important question. And I have learned in my few years in politics to focus on the issue at hand. I think there are important reasons to consider term limits. There are also people who don't support them. I think that's a separate issue. I think the foundational issue, the issue on which we can build a consensus right now, is the issue of preserving 9 justices. But I certainly think that term limits is a subject that's going to receive a lot of discussion over the next few years, and it should.
Thank you.
Thank you. Representative Woodard.
Thank you, Mr. Chair. Thank you, Mr. Bueller, for your testimony, and Representative Johnson for bringing this. We heard a lot in Mr. Bueller's testimony about court packing. Mr. Bueller, I'm just wondering if you have, I would see court packing being beyond adding members to the Supreme Court, but also including things like not holding hearings or taking actions on nominees by an executive. And so I'm wondering if any other states have included asking Congress to add any sort of provision that would require in the Constitution that the Senate take action and hold hearings on nominees by presidents.
You've raised a very important point. And, you know, what we've seen over the last 25 years is a steady increase in the polarizing partisan tactics that have been used in the Supreme Court nomination process. And I think our point is that there have been many examples which some people consider think that there has been inappropriate partisanship in the nomination and confirmation process. And we would argue that if you think that politicians have behaved badly in either party with regard to Supreme Court nominations, if you believe there's been an abuse of power, that is actually an argument for an amendment which protects against further abuse of power. I don't think we can rely safely on partisan majorities in Washington not to abuse their power if they have that power. And we can argue about what specific acts have or haven't been abuse of power. And there may be other reforms which people want to consider. But we think that this simple reform that is overwhelmingly supported by the American people is the need for it is actually increased by what people see as inappropriate behavior by political folks in Washington with regard to the nominations process.
Thank you. Next up is Representative Heiberger. Nope. Okay. Representative Arnberger.
Thank you, Mr. Chair. I am looking up the history of the Supreme Court, and I know that it started off with 6 members, then it went to 7, then it bumped to 9, then to 10, then back to 7, and then now to 9. Could you tell me, and granted this is in the 1800s, do you know, was it bipartisan on jumping up so many times, and when it went to 10 and shrunk down, how they got rid of one justice and all of that?
Sure. Briefly, in 1800, the Federalists were very concerned about Jefferson's party taking over, and they did not want Jefferson to appoint a justice. So they shrunk the court so that Jefferson couldn't fill a vacancy. But Jefferson won such an overwhelming majority in 1800 that they were able to pass a law that expanded the court again so the Jefferson folks could fill the justice, fill the vacancy. In 1807, there was another expansion of the court, but that appears to be an expansion related to the increase in the number of circuits and the size of the country. So I don't think most scholars believe that that was an example of partisan abuse. Then the next expansion was in 1837, and that was as the Jacksonian majority, as Jackson was leaving, and they wanted to expand the court to put more advocates of the Jacksonian Democrats in power, and that was the one in the aftermath of the Cherokee fiasco that I mentioned. Then in 1863, the Republicans, who were then in charge of the country, decided that they needed to expand the court from 7 to 10 because the court was still dominated by appointees of previous Democratic administrations. So I think that counts as a pretty partisan packing of the court. And then in 1866, Republicans realized that the president was Andrew Johnson, who, as you may recall, was actually a Democrat, and they didn't want Andrew Johnson filling the vacancies. So they shrank the court so that he couldn't fill the vacancies. That's also a partisan example. And then finally in 1869, when Ulysses Grant was going to be president, the Republicans decided to expand the court again, so Grant would get a couple of new appointments, and that came to the number of 9. And I think what happened was that those 3 instances, 1863, 1866, and 1869, made people in both parties realize that if this continued, the Supreme Court would simply become a political football. And so that's when the tradition of keeping the court at 9 grew up. And it was strong enough so that in 1937, when Roosevelt tried another court expansion, it was overwhelmingly defeated. And actually, it was Democrats. Democrats, I think, had 80 votes in the Senate at the time. It was actually Democratic opposition that killed it.
Thank you, sir. Last question, Representative Wagner.
Thank you, Mr. Chairman. Mr. Bueller, my question to you is, I do solidly appreciate what you're doing and the bipartisan nature of it. You mentioned in your testimony that it is now backed by more than 80 members of the U.S. House and Senate. Is that still a bipartisan of the current members, or is that all just from one party?
That's a very good question, and it's very unfortunate. Washington is now so polarized. In the last Congress, we had 2 members of the Democratic caucus who supported the amendment. In this Congress, we have not been able to recruit any. We think that that will change as voter support becomes more apparent. I know that here in Kansas, both senatorial candidates in the last election said that they were opposed to court packing. And our strategy is to build at the state level the kind of bipartisan support that doesn't seem to be possible right now in a highly polarized Washington. I believe there are members who oppose court packing, but I think they need encouragement from the states to come out and speak what they know their constituents want and what they know is good for the country.
Thank you, sir. Thank you very much for appearing by WebEx. I have no other questions. I do have a couple of comments. One is, and I just got a text from Representative Johnson, the polling is 3-1 for the measure. And I always, the Supreme Court of the United States always fascinates me. I remember well, I don't remember, but I've read in history, John Jay, the first Supreme Court Chief Justice, actually left the court because he thought it was a do-nothing job. And in those days, all the members of the Supreme Court rode a circuit. They would get on their horse or their carriage and go to different circuits and actually hear cases. Of course, the big decision was with John Marshall, the longest-serving Chief Justice, with Marbury versus Madison, which is something that when they made that decision, they didn't think it had to do with a couple of positions that the president had appointed, though. And I think the court decided in favor of the president, but they made the precedent that they have the authority to rule on all constitutional issues, and it was 40 or 50 years later before that came back into play. When they asserted their authority, we have a precedent that we, the Supreme Court, get to decide constitutional issues. And of course, one of my favorites is Oliver Wendell Holmes, the great dissenter, who was a colonel in the Civil War, got wounded twice, won a number of awards, and he served from Teddy Roosevelt to Franklin D. Roosevelt when he passed. So he always claimed he served from Roosevelt to Roosevelt. But he was also known as the great dissenter, although he wrote more majority opinions than dissenting opinions. But with that, I'm going to close that portion of the hearing and go to the written proponents, which is Derek Smith, Attorney General. Please read that committee. Anyone else appearing that wishes to appear as an opponent or an opponent? I have no opponents listed. Seeing none, I will close the hearing on HCR 5013, and I will open up the hearing on House Bill 2138, Club Drinking Establishment Liquor License Eligibility. Spouse is a law enforcement officer in another county. Reviser, if you would.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. Good morning again, committee. House Bill 2138 would amend KSA 41311 concerning licensure under the Liquor Control Act. So under current law, a person is ineligible for a liquor license if their spouse would be ineligible to receive a license for any reason other than citizenship, age, or residence requirements. So the House Bill 2138 would authorize the director of ABC to issue a liquor license to an applicant whose spouse was a law enforcement officer, even though the applicant's spouse was ineligible to hold such license. I'd also note that House Bill 2138 is identical to 2020 House Bill 2571 that was passed out of this committee last year, and the bill would be effective upon publication in the Kansas Register. Happy to answer questions.
Thank you. Questions of the reviser? Yes, Representative Reese.
Thank you, Mr. Chairman. Matt, does this allow a person to say, I'm a sheriff of a county in Kansas, and my wife wants to open a alcoholic beverage place in my jurisdiction? Does that allow her to do that in my jurisdiction? Is there any stipulation there?
Thank you, Mr. Chairman. So if you look at on page 2 of the bill in paragraph 12, there is that that's basically a list of things that would disqualify a person for a license. And so it's whose spouse would be ineligible to receive a license under this act for any reason other than citizenship, residence requirements, or, and the new language is employment as a law enforcement official. So to your question, an individual whose spouse was a law enforcement officer, they would currently be ineligible, but this is providing an exception for that individual to get a license.
Thank you.
Just a clarification, Matt. And it's also, present law is in the adjoining county, is that correct? That they are barred from having, and we'll be changing that.
Yes, because, yes, correct. That's correct, Mr. Chairman.
Thank you. Representative Hauser, do you have a question?
Yes, sir. Thank you, Mr. Chairman. You know, this language is pretty broad. Reading your bill brief here, it says, this, if I'm reading it right, this wouldn't open it up. This is pretty broad. It wouldn't open it up to be like anybody, including a felon or whatever, could have a liquor license, right?
Thank you, Mr. Chairman. So it doesn't change any other exemption or prohibition. So there'd still be those requirements that if you, if you were disqualified for any other reason, you'd still be disqualified from licensure. And that general prohibition of not allowing a spouse to receive a license if that individual is ineligible, that's still a disqualification. It just allows an exception from that disqualification for spouses of a law enforcement official.
Thank you. Other questions? Committee, this is kind of old law. I remember in Kansas when we used to have to buy the stamps, and some of you that are close to my age remember when you had to buy the stamp to go into a place, and then you had to buy the setups. And then we went to the private club era, where you had to be a member of a private club, which was very good for American Legions and such. And then you had to have club cards that were reciprocal with other clubs. And then we had a vote, I think it was in '83, and Vic probably remembers that better than me. He was much older at the time. Then we passed it, and we had, at that time, dry counties, damp counties, and wet counties, and most of those were along the interstate, the tourist stuff. And what all this started was law enforcement officers. We had a problem with illegal liquor, and that's the reason sheriffs and law enforcement officers were not allowed. They thought that would cause problems. But this has to do with a spouse. Anyways, I've said enough. Probably should have turned to my esteemed colleague, Representative Miller, who could probably, as a former judge, he's probably remembered these cases pretty clear. With that, we'll take the first proponent up, Denise Selby-Cope. Please come forward, ma'am. I have to give you a time limit here, so I'm giving you 3 minutes.
Probably should give me a limit because I'm a long talker. Thank you for hearing me today. My name is Denise Selby-Koch. I am a small business owner here in Topeka, and I am married to the Chief of Police of Valley Falls, Kansas. I first received my LLC for Dirty Girl Adventures in January of 2014. We provide outdoor adventure, gear, and outfitting for mostly women, but to get people outside to explore in Kansas. Part of our dream was to have a base camp and a place to have entertainment, classes, etc. So in January of 2019, we made a business plan, purchased a building in Noto, the Arts and Entertainment District, and at that point became the owners of an event venue and a retail store. And then we hit the tiny little caveat. On the application for the liquor license, it asks for my spouse's name. Please note that I do have a business partner, and while my husband has an interest in my business, it is only that of a spouse, not an owner. He does not own the building, he does not own the business, and I named him. A few pages later, it wants to know if anybody listed on the liquor license works in law enforcement. I thought, that would be great. Extra credit points for law and order. My husband's been in law enforcement for 22 years. However, it was the disqualification of our application, despite the fact that we qualify in every other way. So we thought we'd follow the process. I've been told by numerous people that there are ways to get around this law. It is not my nature to go around laws. It is my nature to follow the law. So what we would like to do is change this law. My understanding of the amendment is that if the law enforcement officer in question has no jurisdiction over the physical location of the business, that that business owner who's related to the law enforcement officer would be eligible to apply for the liquor license, and if they meet all the other criterion, receive that liquor license. So my understanding is that it does not allow someone who has a law enforcement officer with jurisdiction over their physical location to qualify, only if that law enforcement officer does not have jurisdiction. For me, this is a small business thing. It's a very small thing, but this is impeding our small business. We have a retail shop. We have an outdoor courtyard. We aren't really even a bar. We just have live music 2 to 3 times a month. Last summer, even with COVID, we were able to host live music outside with appropriate social distancing, and people were really appreciative of that. That's what we do. We provide quality entertainment to enrich people's lives. And while drinking isn't always the healthiest thing, in our setting, we're not really a regular bar. We are adding that as an added element of choice for our folks. We currently have a cereal malt beverage license. By getting the full liquor license, we would be able to serve wine and mixed drinks in addition to what we already serve. It's a tiny caveat, and I don't want to go around the law. I would like the law to be changed so that it makes sense. And I would be happy to stand for questions.
Thank you. Questions of the proponent? Yes, Representative Miller.
Thank you, Mr. Chairman. Thank you for being here. Would you state for the record that any relationship I may or may not have had with Dirty Girl Adventures was entirely platonic?
Yes. It's a good name, though, right? No one will ever forget it. And if you go outside with us, you will always get dirty.
Thank you for the clarification, Representative. Many of us were wondering.
Yes.
With that, further questions of the proponent? Seeing none, thank you.
Thank you very much for listening to me today.
Committee, I would direct you, I'm sorry, Representative Heiberger.
A revisor question, if it's...
Yes, please.
Matt, could you tell us the section of law where it addresses the law enforcement officer having jurisdiction in the same place as spouse? Is that in a different section of the statute that's not in our bill?
I am actually not sure of where that's located within the amendment or the law.
He's asking the revisor.
Good. Sorry, I'm clueless.
Go ahead, Matt.
Thank you, Mr. Chairman. I'll double check that. You have paragraph 7, which has that general prohibition of a law enforcement official. So it's a license of any kind shall not be issued pursuant to a Liquor Control Act to a person who is a law enforcement official. As to the jurisdictional aspect of it, I will double check that.
Thank you. I will have, thank you, ma'am. Debbie Beavers is on the line, the director of ABC. She's not offering testimony, but she will answer questions. Is there questions for the director of ABC? Debbie, are you on the line?
Yes, Mr. Chairman.
Thank you. Would that be a correct statement as far as you know about whether or not the law enforcement officer has jurisdiction where the bar facility would be? Have you reviewed
Mr. Chairman, the law change does not address jurisdiction. One of the issues that we ran into when we were approached with this bill, first off, it is very old language from Prohibition days and when there was protections by law enforcement. But when we first looked at this change, you run into officers like KBI, KHP that have statewide jurisdiction. So we felt it was best just to remove that.
Okay, so that would be your language then.
We worked it out. I'm not exactly sure who came up with it, but yes, we agreed to it.
Thank you. Thank you. And I understand, I think that was when we had this hearing last time. Some law enforcement officers have general statewide jurisdiction and their wives or spouses would not be able to get a liquor license, even though they may be working in Colby, Kansas, and their residence is in Topeka, Kansas, and still they would not be able to do that. Okay, thank you. Further questions? Yes, Representative Heiberger.
I just want to clarify, so under the current bill, if this passes, then a spouse could get a liquor license in the same jurisdiction in which, the same county, for instance, in which her spouse was a deputy or a sheriff. Is that accurate? Did the
Yes,
question
that
make
is accurate.
Okay, thank you.
Thank you. I'm going to go back to Matt. I think he's doing some research. Matt?
Yes, Mr. Chairman.
Are you able to come up with Representative Heiberger, or is Representative Heiberger comfortable now? He is comfortable. Thank you. I'm sorry? Okay.
The chair could be a little more padded, but other than that, I am comfortable.
Okay. Well, maybe we'll bring you in another chair. But anyways, further questions of the director of ABC? Seeing none. Thank you, Madam Director. I have no other proponents. Is there anyone appearing in the audience as a proponent, opponent, or neutral? Seeing none, I will conclude the hearing on House Bill 2138. Committee, I do have a couple of other bills that we're going to work, but first, as to 2138, is there a move, Representative Miller? Have the microphone.
Motion.
Your motion would be that you would suspend the rule and work the bill today. Is that what you're asking?
That is my motion, Mr. Chairman.
Thank you. The motion is to suspend the rule and work the bill today. Representative Epley is a second. Further discussion? This must be a 2/3 decision. All in favor, say aye. Those opposed, no. The opinion of the chair, the ayes have it. The ayes do have it. The rule is suspended. Representative Miller.
Thank you. Again, Mr. Chairman, I would move that House Bill 2138 be reported to the full House favorably.
Thank you. Do I have a second? Representative Arnberger. Seconded. Further discussion? Seeing none, all in favor say aye. Those opposed, nay. Opinion of the chair, the ayes have it. The ayes do have it.
Mr. Chairman, I have my
objection, I
vote
would like to have Representative.
recorded. I record my vote on that, please.
Yes, you can record her vote. And since the chair is looking in your direction, being a freshman, I'd like for you to consider carrying this bill.
I would be very happy to do that, sir. My sister is the spouse of a law enforcement officer.
I would do that, and with the understanding that be prepared for Representative Miller.
Oh, boy.
Yes, Representative Heiberger is a yes. Okay. But I don't envy you. Let's move right along. If you'll get in your files, if you have a file, or bring it up on your computer, House Bill 2025. Connie, would you kind of explain to the committee what you've done with this new setting so that they understand how to pull those up?
Sure. Can you hear me?
Yep, we got you.
Okay. So IT has created a new drive. It's called the S drive, and it says 4 committees, the numeral 4 committees. So now I will be putting the testimony and any documents that are related to that bill in folders. It'll be under our committee name, and the folder will have the date of the hearing, and any bills that are heard or worked will be in that date. But also, when you don't know the date and you want to look up a bill, there is a place in the upper right corner that you can just type in the bill number and it'll take you directly to wherever that bill is. So it should be a lot quicker and easier for everybody to access it and save me from sending out multiple emails.
Thank you. Yes, Connie always takes care of this committee. But any questions for clarification to Connie? Yes, go ahead.
Thank you, Mr. Chair. Where is the S drive on this contraption? All right, I'll have my children teach me.
I'm sorry, you have to use the microphone.
Okay, so on your laptop, and it has to be a state laptop, hold down the Windows key, R, then put in S and a colon, and then hit enter, and it'll take you right to the S drive.
Okay.
Thank you, Mr. Chairman. Connie in her memo had indicated she wasn't sure if our OAs could follow the same procedure. They can. Great. Thank you.
Connie's always trying to be helpful. Yes, Representative Heiberger.
My understanding is it's only available on state computers, so we can't access this on our home computers.
Okay.
That's correct.
All right. That's
Well, was that helpful, committee? I think. Got a thumbs up. That's good. Anyways, as to House Bill 2025, what is the pleasure of the committee, if any? Yes, Representative Hauser.
Thank you, Mr. Chairman. I'd like to make a motion that we move HB 2025 out favorably for passage.
Thank you. I have a motion to pass House Bill 2025 out favorably. Is there a second? Representative Garber is a second. Discussion. Representative Mosier.
Thank you, Mr. Chairman. I have an amendment. Connie has copies of it. This amendment would
Jeannie, do you have that? Would you pass those out? It's in your file, but I'd still like to have the copies in case people want to.
This amendment would simply remove the county weed supervisors from House Bill 2025. During testimony, there were concerns voiced by agricultural groups that this bill would curtail control methods of noxious weeds. The Kansas Livestock Association indicated it would move from neutral to a proponent of the bill if the noxious weed portion were removed. The part of noxious weed laws that involve inspection of property and the control of weeds is civil in nature and not criminal in nature, and therefore it does not make sense to subject these inspections to requiring warrants. Representative Corbett, who requested the bill, has indicated he is okay with removing the county weed supervisors from the bill. Mr. Chairman, I move my amendment.
If you hold on for a second. Matt?
Yes, Mr. Chairman.
Would you tell us about the amendment? Explain it, please.
Yeah. Thank you, Mr. Chairman. The representative did a good job. If you look at, I have it up on my screen, look in subsection A of the bill. The bill is prohibiting an employee of Wildlife Parks and Tourism to enforce the laws of Kansas, or for a county weed supervisor to conduct surveillance on private property unless authorized by a warrant. And the amendment offered by the representative strikes that reference to the county weed supervisor. So the county weed supervisors would not be prohibited under the bill.
Thank you. Is there a second?
Second.
Second on the amendment? Representative Howe. Further discussion on the amendment? Seeing none. Representative, you may move your amendment.
Thank you, Mr. Chairman. I move my amendment.
You have heard Representative Mosier's motion to amend House Bill 2025 with her amendment. All in favor, say aye. Those opposed, nay. Opinion of the chair, the ayes have it. The ayes do have it. The bill is amended. Further discussion back on the bill. Representative Arnkamp.
Mr. Chairman, I have another amendment. I do have copies here. Would you like me to?
Jeannie will come back and get copies.
Thank you, Mr. Chairman.
While she's handing those out, would you like to explain your amendment?
Yes, Mr. Chairman. So the amendment just clarifies the judicially recognized exceptions to the search warrant. It adds in 3 exceptions: exigent circumstances, consent searches, or the plain view doctrine. So there's a lot of conversation when we had the hearing on just different situations, and there seemed to be some confusion. So working with Representative Corbett, revisers for proper language, they were, or at least Representative Corbett was in agreement to allow this amendment, and he was supportive of it, and it thought it helped clarify some of the questions that came out of the hearing.
Thank you. Matt, would you again explain Representative Arnkamp's amendment?
Thank you, Mr. Chairman. As the representative indicated, so it would remove that reference to a judicially recognized exception to the search warrant requirement, and would spell out the specific circumstances under which they would be allowed to enter the property. And those would be that exigent circumstances, which essentially just means circumstances that would cause a reasonable person to believe that entry was necessary to prevent physical harm to a person or the destruction of evidence. Consent searches, so if the landowner had consented to a search. Or fourth, with the plain view doctrine, which basically would mean that if a wildlife and parks officer saw contraband in plain view, that landowner would lose their privacy interest in that contraband item. Be happy to try to answer any questions about that.
Thank you. Representative Heiberger, are you seconding the amendment?
No, I have a question for the reviser.
Oh, go right ahead.
Matt, are there any judicially recognized exceptions that aren't included in the list in the amendment?
Thank you. Not that I can think of offhand. I'll say that I worked on this amendment with one of our judiciary revisers to try to draft it in a way that spelled out those exceptions. So my understanding is that this would cover them, and the idea was the amendment would be for clarity. But I can't think of another exception off the top of my head now.
Thank you. Amendment has been explained and offered. Is there a second? Representative Carpenter has seconded the amendment. Further discussion on the amendment? Seeing none, Representative Arnkamp, you may move your amendment.
Thank you, Mr. Chairman. I move my amendment.
You've heard the motion by Representative Arnkamp to amend House Bill 2025. It has been seconded. All in favor, say aye. All those opposed, say nay. Opinion of the chair, the ayes have it. The ayes do have it. The bill has been amended. Back on the bill. Yes, Representative Heiberger.
I hope there aren't any more amendments, but I think the 2 amendments we just added greatly improved the bill, but it's still my impression that everything that the bill attempts to prohibit is already prohibited by law, or at least by the Constitution, and I don't think it's necessary, so I will oppose it.
Thank you. Further discussion on the bill? Yes, Representative Arnberg.
Thank you, Mr. Chair. My question is actually for Representative Auerkamp, if he could respond. I should have asked this earlier. I'm looking at all of the opponents. Does your amendment do anything that the opponents were against, or was there any collaboration with especially with law enforcement?
So no, I did not talk with law enforcement on this. And it's going to take a few minutes to try to recall some of the objections. I think there was just lack of clarity in the original bill, and if I can recall correctly from the hearing, a lot of discussion on definitions and different circumstances, and let's say a police chase or something along those lines, where I think the representative from Shawnee said that those are already protected under law. They don't need a search warrant. But just there's a lot of confusion, and I think this doesn't really change anything in the bill. It just adds clarity. So because it's not really changing anything, I'm not comfortable answering your question directly.
Oh, that's fine. I'm definitely not trying to put you on the spot. I just was trying to go through all the opponents, and it's pretty lengthy, so I wasn't sure if there's collaboration or not. So again, I'm not trying to put you on the spot. I just was curious. Thank you.
Welcome.
Yes, Representative Redmond.
Thank you, Mr. Chairman. I know one of the exceptions to a search warrant is fresh pursuit. Would exigent circumstances be covered under that?
I would think exigent circumstances are. I mean, that's the long-held doctrine. When you're in hot pursuit, you don't give up the state line necessarily, nor do you give up at the county line. I think that exigent circumstances would cover all of that. Matt, would you agree with that?
Thank you, Mr. Chairman. I will say I know that there is a case going to the U.S. Supreme Court right now on fresh pursuit in terms of whether that applies to high level like crimes in terms of felonies, or if it's a low level violation. So the Supreme Court may have additional guidance for us at some point on that distinction. So I wouldn't really be able to answer that directly. But I mean, for exigent circumstances, if an individual or if an officer was worried that there was going to be harm caused to an individual, or that there was going to be a destruction of property, that's a clear exception to the warrant requirement.
Was that helpful, Representative?
Just concerned if somebody was, like a law enforcement officer was chasing somebody from 2 counties away and then happened to come on this property, you know, if they can continue.
Right. I see that concern. I personally, I don't know that, and I don't have any legal precedent to give you, but, you know, hot pursuit has always been exigent circumstances to go on private property or wherever. If you can continue to pursue the individual, you don't. In the old days, you probably remember, we used to stop at county lines until the Supreme Court came out and said, no, you can go further than that. You don't remember that? Yeah, well, the advantage I was when I was with the federal government, we didn't have any county lines, but with that. Okay, we're back on the bill. Further discussion on the bill. Seeing none. I'm sorry. Representative Hauser, you made the initial motion. Would you like to renew your motion?
Yes, sir. Thank you, Mr. Chair. I'd like to make a motion that we pass out HB 2025 as amended favorably.
Thank you. Do I have a second on that? Okay. Representative Penn will second it. No further discussion. All in favor, say aye. All opposed, nay. The chair is unsure, probably because I wasn't listening properly, but all in favor, raise your right hand. Okay. 12. Those opposed? What's the count? 7 to 12? 12 to 7, it passes out. Thank you, folks. I'm going to move right along as we have a little time. I did announce that we'd be working this, but not today, but I don't always get to give you that.
Mr. Chairman, may I have my vote recorded?
As a no. Representative Heiberger is a no. Representative Hoyt is a no. Representative Woodard is a no. Representative Wagner is a yes. Representative Howe is a yes. Representative Clayton is a no. Thank you. Committee, I would like to open up House Bill 2340. And for that, I look to Representative Epley.
Thank you, Mr. Chair. I would like to have the committee move House Bill 2025 favorably for passage. I'm sorry. 2340, sir. Sorry.
Thank you. I have a motion by
My computer's
Representative Epley to move House Bill 2340 out favorably. Is there a second? That's the 21. I have a second by Representative Ehrenberger. Open for discussion. Discussion. Representative Blake Carpenter.
Thank you, Mr. Chairman. So I'm not going to obfuscate my position on this. I will be opposing this bill. However, that being said, I think that we can still make this bill better if it is intended to pass. And so, Mr. Chairman, I do have an amendment.
I'm going to have Jeannie come over and pass it out. And while she's doing that, I will ask.
So the amendment that's getting passed out, I specifically just printed off page 4 where the amendment takes place instead of all 25 or 26 pages of the bill to try to conserve a little bit of paper. Basically what this amendment does is it removes the hypocritical stance that the state has taken by allowing smoking inside of state-owned businesses, and makes it to where we are treated fairly, or we are now on an even playing field with private businesses in regards to smoking inside of establishments.
Okay, Matt, would you give us an overview of the amendment?
Matt, for some reason my amendment that I got does not match the one that you're displaying.
Nope.
The one that I was sent earlier was, it just is a little balloon amendment that says redesignate remaining paragraphs, and it strikes lines 35 through 37.
I understand. Yeah, let me pull that up. Okay, thank you. And sorry for the confusion. I misunderstood. So this amendment, if you look on page, page 4, there is a list of exceptions for what the Indoor Clean Air Act does not, a list of exceptions for the Indoor Clean Air Act, and this would strike the gaming floor of a lottery game facility or racetrack gaming facility. So under current law, there is an exemption from the Indoor Clean Air Act for that for those gaming floors, and this would remove that exemption.
Thank you. Is there a second to the amendment? Representative Burris? Okay. Anyone wish to speak to the amendment? Representative Miller?
I have a question for the carrier of the amendment.
Please, sir.
Sir, would you explain what you meant by the use of the word obfuscate?
I was making it to where I was not intending to hide my stance on the underlying bill.
So you were not wanting to render obscure, unclear, or unintelligible the bill?
Correct, and I did Google that definition before I used that word.
Nor did I.
Thank you. This is a significant amendment. Yes. Sorry. Sorry. Yes. Before Epley, I will speak, though. This is a significant amendment. This could have repercussions as to revenue of the state of Kansas. Normally, if something of this consequence, a bill would be introduced, we would take testimony on it from both opponents and proponents and neutrals. And the representative has indicated he's not going to support the bill either way. I find that interesting. But with that, I'll look to Representative Epley.
Thank you, Mr. Chair. Again, just it goes back to don't let the perfect be the enemy of the good. It's not a perfect bill. Maybe there's reasons to get off of it. It's just a simple conformity bill. The more we hang on this bill, the more certain representatives may not vote for it. You all that have been here a while understand that process. Those that haven't been here a while, I will assure you, if we put items on this bill, it will give a reason for someone to not vote for this bill, and it will fail. I think the underlying concept of conformity over my about 2 to 3 year journey with this issue has been very interesting. I think keeping it simple is very important. I view this as an adversarial amendment. I know it's potentially well-intentioned, although I think that's questionable, particularly when the underlying carrier of the amendment is not going to vote for the bill and is taking your time and everyone's time here to talk about a bill that they're not going to vote for because they want to poison it a little bit more. So having said that, I think we should hear from the maker of the amendment, but I would urge you to not vote for this amendment. Thank you.
Mr. Chairman.
Please. Yes.
Point of order there. I believe Mason says that you're not supposed to try to divine what people's true intentions are or not. So I just want to make that clear to the representative.
I understand, but you were the one that started.
Yes. So while I did say that, there's a very good chance that I'm not going to support this bill, and even if these amendments that I have do go on, I do have a problem with the underlying bill. However, I'm not trying to make it a poison pill. That's not my intention. I'm trying to make better laws. And so to try to impugn my reasons for doing this, I think are unacceptable. Now, with that, I'm not going to close or anything like that, but I'm just saying that if this truly is going to become a law, I think that the state needs to recognize the error of our ways when we carved out a special provision for state government businesses, but then made it to where all private businesses have to operate under a different set of rules. In my opinion, that is wrong. And that is why I'm bringing this, because I'm trying to right that wrong. Thank you, Mr. Chairman.
Thank you. I would, and I appreciate your comments. But I do know that this is a very significant change in the law. I would have preferred that you enter a bill and let it go through the vetting process where I would have proponents here, I would have opponents here, so I can make an informed decision. Sometimes we rush to judgment without knowing the consequences down the road. And then we end up with trailer bills to fix the problems that we've made. I do have a problem with the amendment because I know the impact it could, maybe not, could have, but without vetting and having people come in front of us and tell us what's good or what's bad and let us make an informed decision. I can't make a decision if I'm not informed. It sounds good, but I don't know. And we should not do things that we don't know what the consequences are. That's the reason I'm slow and I'm methodical. I want to keep the committee informed. Some committees chairs don't want to do that. I try to keep you informed on everything. And so I do not consider this a friendly amendment. But with that, further discussion. Yes, Representative Epley.
Mr. Chairman, I want to go on public record and just offer my apologies to the representative from Sedgwick. I did not mean to overcharacterize his intentions, and that was an error on my part, and I apologize for that. I just think that we need to all understand here, folks, that sometimes incrementalism is better than trying to go all the way because it will give people reasons not to vote for a bill. And so however you want to state it, I think this is the incremental right step at this time to simply be conform and be uniform with the federal law. Thank you.
Thank you. Further discussion on the amendment? Representative Arnkamp.
Thank you, Mr. Chairman. If I may ask a question on the revisor.
You may.
Thank you, sir. So the amendment strikes the exception for kind of the gaming floor, the casinos. Matt, for private businesses, are there currently any exceptions for, let's say, whether it's a restaurant or a manufacturing facility or, let's say, a law office, or are there any exceptions for private businesses currently in the statute?
Thank you, Mr. Chairman. So there's a couple specific private businesses spelled out, such as tobacco shops, a Class A or Class B club, private club in designated areas where persons under 8 years of age are prohibited. So there's any benefit cigar dinner or cigar dinner of substantially similar nature for charitable purposes. So there's specific examples, but generally speaking, no, for all private businesses, there's not an exemption.
Thank you. Yes.
So for clarity, if I had owned a restaurant, there's no way for me to get an exemption on like a bar and grill or anything. Similar to what the casinos have.
There is not a general exception for restaurants and bars.
All right. Thank you, Mr. Chairman.
Yes, Representative Potter.
Thank you, Mr. Chair. On this, when it comes to private businesses, I do believe that if it's like a private club where you have to have a membership to enter, you are able to still smoke within the building, like a pool hall that is membership only. So I believe that that would make this exception when it comes to a state-owned fair, because it does provide a private business also to allow this within the building. Thank you.
Thank you. Yes, Representative Heiberger.
I'm not going to state an opinion on the amendment, but I would say that I don't see the public health basis for exception number 4.
Thank you. No other discussion? You may move your amendment.
Thank you, Mr. Chairman. In closing on my amendment here, this is something that has passed this committee before with overwhelming margins, and so I figured it'd be beneficial to pass or try to bring this amendment again. In my personal opinion, it makes the bill better. It doesn't poison it. I think that if the state of Kansas wants to be in this kind of business, that we should be on the same footing as everybody else. And so with that, Mr. Chairman, I move my amendment.
Thank you. Representative Carpenter has offered his amendment. He has closed. All in favor of amending House Bill 2340 to the Carpenter Amendment, say aye. Those opposed, no. Opinion of the chair, the ayes have it. Division has been called for. All in favor, would you raise your right hand? All those opposed? Stand up. Is it 11? 11 to 10? 11 noes, 10 yeses. The motion to amend fails. We are back on the bill.
Mr. Chair, may I retain the floor?
I'm sorry?
May I retain the floor?
You may.
Thank you, Mr. Chairman. I do have another amendment.
Please. While it's being handed out, would you explain your amendment?
Yes, Mr. Chairman. So I think under current law right now, the problem we have is if this bill does pass, there's nothing stopping any counties, municipalities, so on and so forth from changing what state law basically is for their own local municipality. For instance, the current state law is at 18. However, there are some municipalities that have raised the age to 21. So the problem that I have is that if a municipality has already raised it to 21, let's say we pass this bill and we do raise the smoking age to 21, then the problem that I'm going to end up having is that, well, what's to stop that municipality from saying, well, 26 is the proper age to be able to smoke, or these flavors are banned, so on and so forth. So basically, my amendment makes it to where all entities in the state of Kansas have to follow state law in regards to whatever it is we pass as with our tobacco policy. Thank you, Mr. Chairman.
Thank you. Matt, would you explain the amendment?
Thank you, Mr. Chairman. So under 793322, violation of subsection D is a cigarette or tobacco infraction for which the fine is $25. The amendment would add a subsection that would preempt a city or county from enacting an ordinance or resolution to conflict with any provision of the Cigarette and Tobacco Act. And then there's a conforming amendment made in 793393, striking this reference to cities adopting ordinances concerning cigarette or tobacco infractions. I'd be happy to try to answer questions.
Thank you. Questions of the reviser or the carrier of the amendment? Yes, Representative Epley.
Thank you, Mr. Chairman. I would ask Matt to comment on the status quo. In the status quo, is there the right of preemption at this time? Can you comment on that, on the smoking age? I think the committee would appreciate knowing that information.
Thank you, Mr. Chairman. I don't have specific knowledge about what ordinances have been adopted by cities, other than the fact that under current law, they have the ability to do so.
So again, just for clarity, Matt, they have, as far as you can from your position as reviser, there is a right of preemption with the localities at this time in the status quo from the state standpoint.
So I would say that the cities are not prohibited from adopting an ordinance concerning cigarette or tobacco infractions, and this amendment would prohibit them from adopting anything.
So not only would this be embedded, thank you, Mr. Chairman, not only would this be embedded in this bill, but this would change the status quo as we know it currently, correct?
Thank you. I think I may need clarification on what you mean by the status quo. Just that right now, cities have the authority under law to adopt ordinances or resolutions concerning cigarette or tobacco infractions, and the amendment would remove that authority and require them to would prohibit the cities or counties from not enacting an ordinance that was different than the requirements under state law.
Thank you. Thank you, Mr. Chairman.
Thank you. Representative? I'm looking at the clock.
There does need to be a second on this.
You may, but then I would, go ahead.
I'm saying somebody needs to second my motion.
I'm looking for a second. Second, Representative Garber. No further discussion. You may move your amendment.
Thank you, Mr. Chairman. I think that this law is changing current status quo as it is to 21, and I think that we need to make sure that we don't have issues with somebody raising it past that, banning flavors, or going above and beyond what state law is. And so I just want to make sure that we have that. So, Mr. Chair, I move my amendment. Thank you.
Thank you. As to the Carpenter Amendment 2, further discussion. He has closed on his amendment. All in favor of his amendment, say aye. Those opposed, no. Opinion of the chair, the noes have it. Division has been called for. All in favor, raise their right hand. Those opposed? Twelve noes. The motion to amend fails. Back on the bill. We'll look back to Representative Epley.
Chair, just real quick, may I make some final comments, Mr. Chairman?
You may.
Thank you, Mr. Chairman.
But make it very quick.
I will make it very, I do apologize, committee. I will make it as quick as I can here. So the grant funding that we are receiving from the federal government is, according to the analyst records from last year, in fiscal year 2020, is $12,338,139. 10% of that, if it's withheld, is $1.2 million. However, the revenue that we are going to lose is $7.1 million if we pass this. So if you're looking at this from a fiscal aspect, we're going to lose roughly $5 million on it. So I just wanted to point that out, $5.9 million if we pass this piece of legislation. And so if you're looking at it from a fiscal standpoint, it's not a good idea. Mr. Chair, I'm trying. And so from the fiscal standpoint, it's not a good idea. Additionally, I think that we can trust our citizens to make decisions for themselves and have less nanny state government. Thank you, Mr. Chairman.
Thank you. Representative Epley.
Thank you, Mr. Chair. Just to respond, I think it's...
Quickly.
I would move my bill, House Bill 2340, Mr. Chairman. Thank you.
Thank you. Have a second? I have a second. I have a motion to pass out House Bill 2340 favorably. All in favor say aye. Aye. Those opposed, no. No. Opinion of the chair, the ayes have it. Division has been called for. All in favor of passing it out favorably, raise their right hand. Those opposed? Raise your hand again. Against. 11 in favor, 10 against. The bill passes out favorably. Committee, next week we will be on the floor. We'll be having, I think we're going to have an alcohol day where a number of the bills that we passed out, we will have that day. The following week we'll be taking up other issues. Hopefully we'll be taking up some Senate bills. I want you to have a good weekend. Again, apologize for working today. Some of the other committees are not. So if you have no other committee, Representative Miller.
Mr. Chairman, would it be out of order to wish Representative Garber a happy birthday, even though it's still 13 and a half hours away?
I had that on my notes, but first he has to tell us how old he is, if he wishes to do so. I have a month before I reach that, so you're older than me, but you're probably thinking the same thing. We're just lucky to be there. With that, committee, we stand adjourned.